It's my prayer actually that all this evidence, paragraphs 10, 11, 12, 13, 14, and 16, 19, and so on, my Lord, all based on hearsay evidence. Itself, my Lord, the submit is inadmissible, cannot be considered during trial going forward. Because we are not making headway. Makes sense. Will not be considered, and I feel that it will be expanded. From record of being hearsay. Not 10, 11, 12, 13, 14, 16, all 16, 18, 19, all 19, 20, 20, the elementary style under section 59 of the Evidence Act. I pray that all these averments be expanded off the record of being hearsay evidence. Lord, I submit that evidence, admissible evidence, must be of that witness who says he or she saw the information that was there, or heard. My Lord, specifically, we have several cited cases, one of them being Dr. Kisa Messenger versus Dr. Museveni. This area was canvassed, and the ratio was that such evidence would be expanded. The Lord, we will submit on that authority. The starting point will be order 19, rule 3, which is rule 3.1, that affidavit evidence must only be restricted to information by the deponent. The courts have canvassed this area. It's a settled area. Another places are going to provide actual authorities with punishment for the punishment. A lot of that yoga
Make your prayer and I will consider.
another understanding.
But I'm not telling you.
But our understanding cannot have been that now then how do we continue examining with evidence that we have already maybe then that means that our objective is sustained in expand.
I have
Because if you're going to go
I have said that I will consider it due to the general evaluation. That's what I said.
Yes, I'm not because on this issue, let him complete the submission. Let's conclude the submission then. Yes. But the first one is that Paul Kawanda Semoki, Zakaria Ogun. That's the Atuyanude General. Constitution Petition number 1, number 3, 1999. But we also have Chris Mobiru. I'll give you the rationale. Chris Mobiru, the Attorney General. Constitutional Petition number 1, 2001. Then we have which is arrested. Assets, item 7. Presidential Electoral Petition number 1, 2001. But this is the rationale in this case. That briefly, my lord, that election petitions are tried are supposed to determine the merits of the case. So the only evidence you can have on record is through affidavits. If you sneak in inadmissible evidence, like hearsay, there is no any other chance of getting that evidence off the record. And my lord, because we are not proceeding by witness statements, the only form we can have evidence of record is by affidavit. So where the deponent is giving information from other people who are not before court, that information is not in affidavit, not addressed.
As you have pointed out, paragraphs 10, 11, 12, 13, 14, 16, 18, 19, and 20.
Yes, my lord, and
These are the ones which I have not checked.
yes, my lord, and lastly, to emphasize this, my lord, even evidence from the advocate is not admissible. Even that from the advocate. And my lord, I will quote that. Except the advocate who is representing the deponent. The affidavit where it reads that, my lord, I have been informed by my foresaid advocates. So, my lord, the other stuff that is relevant to this situation from Zakaria the ones from the advocates. Lord, we have a paragraph that my lawyer is that when advocates 14 and further informs that my lawyers yes, my lord. So, my lord, the sense of my submission is that information one from the agents, it is being quoted by Nambi and information from the lawyer, both are not admissible. They are closed out by the rule of hearsay because she cannot speak or vouch for the truth of such statements unless we are going to have Mr. Gabriel stand to speak to it.
Well, my lord, again, my understanding, courts are writers. What is the next development? Yes, my lord, we have left over. My lord, because an application, my lord, written out of these cases, a party and rightfully object to commission. During trial, if I object, yes, my lord, if I object, then it behoves that the other side has to be had on this issue. Then it is to become there. That's my understanding. Then we can receive. Unless they choose not to. The other side, yes. Yes.
I'm satisfied with the objection on a number of reasons. Mr. Means referred section of the Evidence Act. Firstly, my lord, by dint of section 1 of the Evidence Act, that act does not apply to evidence. By dint of section 1 of that act of the Evidence Act, it does not apply to evidence. Secondly, my lord, the witness in paragraph 23 of her affidavit in support of the petition clearly states that what she is stating above is to the best of her knowledge and belief from sources she has disclosed. In each of those paragraphs that my colleagues have referred to, the witness has stated the source of the information. She has stated the source from each single one of them. And my lord, there is nobody that she has mentioned who has not imposed an affidavit to this source. Every person she mentions in any affidavit, in any paragraph, has imposed an affidavit to this court, and the record reflects that. Decisions are bound, my lord, with only hearsay. If she states where she gets information from, and the person who she's getting information from is not talked of by way of an affidavit, that's the only way you can call it hearsay. Where my lord, she states that Kalure informed me and said Agent Kalure is here with an affidavit, that ceases to be hearsay. And all of those affidavits of persons she referring to in her affidavit are before this court by way of evidence. Now, my lord, I also tend to think that we are reading from different decisions of basic and 7. My lord, in that case, Mulenga, yes, it was part of the lead decision. Here that my lord should be. I should, however, comment especially on affidavits required under Rule 4, Sub-Rule 7, and A3A of the Election Petition Rules to accompany the petition and answers thereto. The said rules require that those affidavits shall set out the facts on which the petition is based, and the respondent will rely on as the case may be. Invariably, however, the parties have to rely heavily on factual information they receive from their agents and other witnesses in order to comply with that requirement. In my view, is what Mulenga says, in my view, therefore, in relation to those affidavits from those agents, Order 17 Rule 3, which talking back to now is 19, of the CPR has to be applied with such modifications as permits the petitioner and the respondents to include in those affidavits facts which they depend from such information. My Lord, that decision was referred to by the Court of Appeal in the case of Mpanga, Farouk versus Sekuluge Isaac, and I'm reading from that decision. After quoting all of that, my Lord, the Lordship said in the Court of Appeal, after quoting that part of the decision, that in the instant case, a reading of paragraphs 5A to M of the petitioner's affidavit, just like in this case, my Lord, shows that what was stated therein was information based on what was provided from polling agents and supporters, as in this case. The petitioner, the Lordship said, the petitioner clearly disclosed the sources of his information, who also saw affidavits in support of the said allegations based on their knowledge. They held, the Lordship in St. last round of elections, they then held, we find that the learned trial judge found that the disclosure of sources of information by the petitioner was sufficient, following the majority decision in Kizabesi versus Omusango. That was the holding of the Lordship. It's not here. My Lord in Muhindo, Rehma. In Rehma versus Winfred Kiza, EPA number 29 of 2011. The Lordship said that in these cases, the candidates rely on appointed agents, and as such, should have included that specific source of information, as has happened here. In the affidavits, or else they file separate affidavits from the agents who witnessed the occurrences. That's what we did, my Lord. And the Lordship then held that the learned trial judge cannot be faulted over this aspect of the matter. So my Lord, our submission is that first, the evidence fact relied on, that's the evidence. Two, the petitioner has disclosed. Three, those persons from whom she has sourced that information have all deposed affidavits and they're on court record. Number four, the Lordship said that ceases to be here. Candidates is expected to be in each polling station up to 197. She relies on information from supporters, from campaigners, from agents. It's only hearsay if she says Musi told me this and there's nothing that Musi. If that the case is, the affidavit is there, that ceases to be hearsay.
Yes, my Lord. The starters, because it's true that all these witnesses depose affidavits and that they disclose information that may be implied. Submission is not premise. I use the word elementarily, the principle in section 59. Elementarily is cardinal. Evidence has to be evidence of soul. But our submission is rooted in order 19, 3, 1 and 2. My Lord. Submit that hearsay evidence is prohibited. Even belief is prohibited under the law. Is prohibited. Submission under order 19. 3, 1 and 2. My Lord, why I raised this issue at this point? I was finding difficulty proceeding with agents who are already questioned. They disclosed evidence information that she does not have, my Lord. Raise this point, my Lord. That is why it would be proper that we expand those paragraphs in the Constitution. Because how then do I know them? When I already have a ruling on record that you That's why I raised it at this point. He's telling me they are there. I cannot access them. The witness is saying, I don't know, I brought witnesses. But from my so I'm at pains, my Lord. I would not have raised it. I pray. And these cases, most of them somehow, both sides participated. And we know they are distinguishable. My Lord, to distinguish them properly, since my colleague submitted in the authority, just for distinguishing purposes, the rest of this. Okay.
About the decision I'm referring to, really not in my Lord. Decision I'm referring to, decision Justice Odo in the 2001 election. My Lord, this is, I need really offer a proper context of why, where you're using affidavits, the courts are very strict on what can be admitted. Also, from the side of the people. My Lord, in election petitions and constitutional petitions, the only way by which you can bring evidence is through affidavit. My Lord, the case goes further to state that hearsay, or what we can categorize as hearsay, will only be admissible in interlocutory matters. Say if I have suit and I want to get an injunction, then I can go to my lawyer, and my lawyer informs me that that client discloses prima facie the case, and therefore I qualify to be given an injunction. My Lord, that is the only way you can have hearsay evidence admitted on record in interlocutory. It does not help, especially for the petitioner, to bring paragraph 23. If Mr. Kalule read the decision that I read, he knows that fact was the contention that all the affidavits that they sought to strike off the record had that statement that what they stated, we have disclosed the sources and belief, and court said no, we cannot nullify or confirm a candidate of an election on the basis of one, belief, two, information that is sourced from another party. That is, my Lord, the rationale. But my Lord, I read the excerpt. This is from Omusango. It says that except in purely interlocutory matters, affidavits must be restricted to matters within personal knowledge of the deponent. Two, they must not be based on information or by expression of opinion. It goes on, my Lord, affidavits should strictly be confined to such facts as the deponent is able of his own knowledge to prove. Affidavits by persons having no personal knowledge of the facts and merely echoing the statements of the client cannot be used at the hearing. This is where we have. That Nambi says EliasNalukoola is not a duly elected member of Parliament. What evidence must court rely on? Nambi was told by her lawyers that there was non-compliance. Nambi was told by her lawyers that the election was marred by great violence that affected the results in a substantial manner. She does not have that knowledge. She is quoting other people. That is inadmissible. And that is, so my Lord, the issue of Court of Appeal, High Court, it is really, Mr. Kambe has an affair with it. We have a Supreme Court decision. And my Lord, we cannot go behind. We cannot go back, my Lord.
My Lord, that was really disenfranchisement and the rest. You can go with legalities. Agent Nambi. Let's go to the paragraph 16. That's where we start now. Since if it is considered otherwise, not that I believe it. 16 is it your testimony under 16 that Gordon Saleh informed you that the first respondent campaign on the polling day by saying EliasNalukoola. Is it your evidence?
Yes, ma'am.
Is EliasNalukoola a campaigning statement? EliasNalukoola, is it a campaigning statement? Qualified. That's 16.
Yes, my lord.
Nambi, when you arrived at the polling station, you took us through. Is your statement that you would mention your name? That you arrive at the polling station, they check if you're a registered voter. Did you mention your name when you arrived at the polling station?
I mentioned it.
Okay. Thank you. Did that mention of name be right to state that you campaigned at the polling station?
My lord,
You, Nambi, you are the one who was there. You said you went there with your husband. Did your husband state his name? Did your husband state his name? Would it be right to state that your husband campaigned for you at the polling station?
no, my
And where is the evidence? The matter of evidence, the court of evidence. Where is the evidence that Nalukoola is in anywhere? I've seen in your petition pictures, photographs, what you have any certainty. Yes or no?
My lord, as per the affidavit, that is valid.
Do you have
The affidavit details, that's how it came to this.
No, you are not there, you are not there. That supporter, they not come to court. That evidence on the question is it there? Yes or no? So that's the rush. Is it there? It's a yes or no?
No, my lord.
Okay. Are there names of persons that he influenced as per your statement? Say these campaign statements to influence. Are there names of such people? Are there names? Yes or no? Of voters in your petition?
The names of the voters are not to be included.
Are there numbers? The names are
But
not
the
there.
polling station is mentioned.
The names are not there. Are there numbers? Was it a crowd? Are there numbers in your petition?
He campaigned, my lord, the first respondent campaigned among the supporters.
Are there numbers? Simple. There are numbers or not?
No, my lord.
There are no numbers. Would I be wrong? Is it possible that Gordon Salim Saleh is an NRM supporter? Is it a possibility? Gordon Salim Saleh. Is it a possibility that he can be an NRM supporter? Or is he one?
Yes.
Yes.
That is good.
So, would he then be your supporter? By being NRM, would he be your supporter?
My lord, that is not ascertained in the
Would he be?
But if he were an NRM supporter, yes, he would be my supporter.
So would I be wrong to presuppose, not saying you know, to presuppose that he may have voted for you?
No, not my lord.
Presuppose.
My lord, I object to that question. In the advancement of an election petition, a question cannot be asked as the choice of a particular voter. That's banned by Section 102 of the EA.
Let's move right. Would you ascertain? You said polling station. Would you ascertain? Within how many meters? Within how many meters? You say polling station is open. If you don't call what's there. The parameters. The distance in where you were standing there. I don't think it was in the ballot box. The distance, would you ascertain? Yes or no?
The distance between where he was, is that what you're asking?
Yes. Because you said polling station, stated bits, said communication.
My lord, the detail I captured in my affidavit is from the polling station, which is KAT AMG.
So you cannot ascertain the distance because it's important. You cannot.
No.
No. So then, do you have any evidence or any report from your appointed agents? A report about this campaigning, the polling day, and how it happened. A report.
My lord, yes.
Is it before this court?
I have a full report as I have stated in this affidavit.
You do not have a formal report. Okay, let's go to another element. Again, paragraph 16. 16.2 particularly. Telling voters amani government Mugalyamu olukwe. He said, literally translated, do not betray people power. What does money government mean? The efforts of the people. Does the efforts of the people mean Nalukoola? Don't betray the efforts of the people. Does it mean voting for Nalukoola, according to you?
My lord, in this paragraph, 16.2, page 014. It goes on to say, do not betray people's powers. So it's not in isolation.
That's what was stated here. Does this mean alcohol? These are specific illegalities, even one can have a problem. An allegation. Did it mean alcohol? Does it mean evils of people? Does it mean? It's about your interpretation. If someone said it to you, or said it to someone, should it qualify? I'm obliged.
16.2.
My Lord, I have a question on every electoral offense.
16.2, my Lord, it is yes attributed to the first respondents, campaigning among the supporters on polling station in Kazan.
My question, it's about my question. Does it mean vote for Nambi? Manigaba said, you don't know.
My Lord, as stated in 16.2, it means vote for people power and was the candidate for the job.
Oh, so Nambi was a candidate for people power. No, he's not here. Is it your statement that people power sponsored the candidate?
My Lord,
Statement.
I meant to say that this was attributed to the first respondent.
So people power did not sponsor any candidate.
My Lord, people power is I understand that.
Yes, 16.3. Do you have proof that the first respondent had agents in 16.3? Names of Chibirige Musa? Yes.
So the matter is still over till 2 p.m.